We're going to call the hearing to order, and if our panelists take seats, that's to help us get our arrangement for how we ask questions. They've called votes. So we're going to adjourn, recess, going to go vote, and then we're going to come back. So you can keep walking around, but your place in line has been saved. So with that.
You've done an excellent job so far, however.
Okay, we will wait for people to come back in. As you can see, it is a crazy morning around here. A lot going on, and we've got the health hearing that is also taking place. All right, the committee will reconvene, and I recognize myself for 5 minutes for an opening statement, and I want to welcome you all. I apologize to everyone. We thought we had votes at 10, and then it was going to be 10:10, and come on back over here, don't, you know. It's just one of those days, a getaway day, an omnibus day, and we're going to go ahead and start this hearing because you never know when the bell is going to go off. A little less than 2 months ago, we did our first legislative hearing. This is our second. We sat here in this room discussing 25 pieces of legislation addressing broadband infrastructure, representing all the views on the table. Last month, we shocked the naysayers by shepherding many of the subcommittee's top priorities through the full committee unanimously in Ray Baum's Act. Today, just as that package is about to head to the president's desk, we've got 4 more bipartisan bills that address everything from combating illegal pirate radio to identifying ways technology can help prevent suicide across the country. I couldn't be more pleased with the work of members of the subcommittee and all the important initiatives we've gotten some work going on this year. I'd also like to commend Congressman Stewart on being a champion for the National Suicide Hotline Improvement Act, which currently has 78 co-sponsors, including 7 of our subcommittee members, Bilirakis, Clark, Eshoo, Flores, McKinley, Rush, and Tonko. Suicide is the 10th leading cause of death in Tennessee, and this legislation would make it easier for those facing a mental crisis to get the help they need with a dedicated N11 number. We'll also be discussing Mr. McKinley and Mr. Welch's bill, the Rural Reasonable and Comparable Wireless Access Act, which takes a new perspective on getting wireless broadband out to rural areas. This subcommittee has long been looking for ways to close the digital divide. And today, we've got another potential solution, bipartisan, I will add. And speaking of infrastructure, another bill which could help spur investment in broadband infrastructure is Mr. Latta and Mr. Schrader's Small Entity Regulatory Relief Opportunity Act, or SARO. Small entities across the country, regardless of technology, face miles of red tape at the FCC to comply with regulations designed for large providers. Money that those small, often rural entities spend on complying with regulations is money that could be used for investing in broadband deployment. And it's important for us and the Commission to keep this in mind instead of assuming that one size should fit all in every case. Finally, we'll be discussing Mr. Lance and Mr. Tonko's Pirate Act, which many members of the subcommittee have worked on, including Mr. Collins, Tonko, Bilirakis, Green, Moulton, King, and Dingle. Illegal pirate radio disrupts access to important public safety communications, including our nation's emergency alert system and critical aviation frequencies. These illegal broadcasts deprive Americans of important programming provided by legitimate license holders serving the public interest. It's high time we pay more attention to the harm being done to consumers and broadcasters alike. I'd like to thank our witnesses for being here. And Mr. Lance is not here, so would anyone like the 1 minute? Mr. Latta, you're recognized.
Well, thank you, Madam Chair, and I appreciate you holding today's hearing on these 4 bills, including my own, the Small Entity Regulatory Relief Opportunity Act, or SERL. Recognizing that small businesses are the engines of our economy and do not require the same level of regulatory oversight as large entities, the gentleman from Oregon, Mr. Schrader, and I put forth a common sense proposal to create a regulatory environment that encourages innovation, spurs competition, and fosters consumer choice. SERL offers a pathway for regulatory relief for small entities by directing the FCC to streamline their existing waiver process. This will benefit small business and their customers by providing greater certainty, fewer costs, and administrative efficiency. Since introducing H.R. 3787, Mr. Schrader and I have made countless efforts to consider all stakeholder feedback and input, and today's discussion is a continuation of those efforts. I look forward to hearing from our panelists, and I thank the gentlelady, the chair of the subcommittee, for yielding. Thank you.
Gentleman yields back. Mr. Doyle, you're recognized.
Thank you, Madam Chair, for holding this hearing, and thank you to the witnesses for appearing before us today. Today we are considering 4 pieces of legislation. In particular, I'm happy to see before us a bill by my good friend Peter Welch, H.R. 2903, the Rural, Reasonable, and Comparable Wireless Act. This bipartisan legislation seeks to establish national standards for mobile service, mobile data service, and broadband services in rural America that are comparable to those in urban America. I know this is an issue that my friend and colleague is very passionate about, and as this bill points out, under the Communications Act, Congress tasked the FCC with ensuring that rural areas had similar access and availability of service as their urban counterparts. But I don't have to tell anyone here that we've fallen short of that goal. Get on a highway that isn't the I-95 corridor and wireless service gets spotty fast. Or move from Pittsburgh or D.C. to rural Tennessee and try to get fiber internet. We need to make sure that people in rural America can get the same kind of widespread, high-speed access as we have in urban areas and along urban corridors. I'm proud that committee Democrats have proposed a plan with Ranking Member Pallone's Lift America Act that seeks to close this gap with a $40 billion investment in capital investments. Congressman Lance and I have also introduced the Airwaves Act, along with a number of our colleagues on both sides of the aisle, that sets aside 10% of the revenue from the spectrum auctions set out in the bill for deployment of broadband infrastructure in unserved and underserved communities in rural America. Another bill we have under discussion today is Congresswoman Bernice Johnson's National Suicide Hotline Improvement Act, which would require the FCC to work in coordination with SAMHSA to explore the feasibility of a 3-digit dialing code similar to 911 or 311 for suicide prevention. This legislation passed by UC in the Senate a seemingly rare feat these days, and I hope we can continue to move this important legislation forward. We're also discussing a bill on unlicensed radio broadcast today. And while I've heard anecdotes that there is a problem on the rise in major cities like New York and Miami, I am concerned that the proposed solution is to increase fines for these broadcasts tenfold. Years ago, I worked with Congressman Lee Terry on the low-power FM radio legislation. We saw that there was an issue of illegal broadcast, but also that there weren't many opportunities for communities around the country to express themselves on the air. We sought to address this by increasing the opportunities available to these communities by opening a low-power FM application window, which resulted in thousands of new stations across the country. As we consider this legislation, I think we need to balance the legitimate concerns of broadcast licensees with the limited opportunities for expression available to some communities. My hope is, as we consider this bill, we can take an approach that addresses both groups' needs. And the last bill we're considering today is Congressman Latta's H.R. 2787, the Small Entity Regulatory Relief Opportunity Act. I'm very concerned about this bill. The way that it is drafted would open up a huge regulatory hole at the FCC and would enable companies with over $1 billion in revenue to be exempted from a wide range of rules intended to protect consumers and, to be honest, small businesses as well. I'm very skeptical about the merits and need for this legislation. With that, Madam Chair, I want to yield the balance of my time to my good friend and colleague, Mr. Welch.
Thank you very much. You know, as we sit here today, we all know that rural broadband infrastructure is insufficient in rural America, is being left behind. The FCC, in my view, is not meeting its congressionally mandated goal, which is ensuring rural America has access to, quote, reasonably comparable service to their urban areas. We basically haven't had a definition of what reasonably comparable is. And my bill with Mr. McKinley is designed to get at this issue and make reasonably comparable real and meaningful in rural America, just like electricity was when we made that public policy commitment in the 30s to wire rural America. The FCC, under this bill, would have to gather data from the 20 most populous metro areas and detail the average signal strength and speeds of mobile voice and mobile internet services. It would also require the FCC to determine the extent to which mobile and fixed broadband service provided in rural areas is reasonably comparable. That's what the bill would do. It is absolutely essential we do that in order to be able to say yes or no that rural America has reasonably comparable services. Thank you, Madam Chair, and thank you, Ranking Member Doyle.
Gentleman yields back.
I yield back.
Chairman Walden is not here. Are there members seeking to claim the chairman's time for an opening? No one seeking the time? Mr. Pallone, you're recognized for 5 minutes for an opening statement.
Thank you, Madam Chair. Our hearing today will examine 4 bipartisan communication bills. Though communications is the thread that binds them all, they each touch on vastly different but important issues. First, I'm pleased we're considering the National Suicide Hotline Improvement Act of 2017, which aims to quickly connect individuals experiencing a mental health crisis with a professional. Suicide is the 10th leading cause of death for people of all ages, and every year hundreds of thousands of people are injured in attempted suicides or other mental health emergencies. And this bill would require the Federal Communications Commission to study how to establish a nationwide 3-digit number to access the National Suicide Prevention Lifeline. With rates of suicide increasing each year, we must do all we can to get support services to those in need. And I'd like to thank one of our witnesses, Mr. Madigan, for all the important work you do at the American Foundation for Suicide Prevention, and thanks also for being with us today. We'll also be discussing the Rural, Reasonable, and Comparable Wireless Access Act introduced by Congressman Welch and McKinley. This bill would shine a light on the quality of voice and broadband services offered in rural areas. It would direct the FCC to examine whether people in rural communities actually receive the same level of service as those in urban areas. And the FCC has talked a lot over the past year about improving connections in rural areas. This bill would require the FCC to collect and analyze the facts on the ground and make sure that it's actually getting the job done. I'm also glad we'll be discussing the problems caused by pirate radio broadcasters, people who broadcast illegally on our public airways. Pirate broadcasters flout the law and interfere with the licensed broadcasters who follow the law. These pirate broadcasts can be frustrating for people, but more critically, they prevent people from hearing important communications and public safety information in times of emergency, and that's simply unacceptable, and I look forward to hearing about ways that we can work to solve this problem. And finally, we'll discuss the Small Entity Regulatory Relief Opportunity Act. While I certainly appreciate the difficulties faced by small businesses across the country, I have concerns with the ways this bill would try to solve those problems. The bill would allow the FCC to roll back or delay consumer protections for subscribers of telecommunications and cable companies that serve as many as 6.5 million customers. These supposedly small businesses could be larger than 35 states. And many of the millions of customers of the providers have few or no choices. But aside from size, given the current FCC's animosity for consumer protections, I don't think this is the right time for Congress to encourage the agency to strip away more safeguards for millions of people. And we would be better off figuring out ways to better protect the American people. So I look forward to the discussion today and hearing from all the witnesses, and I'd like to yield my remaining 2 minutes to Mr. McNerney.
Well, I thank the ranking member for yielding, and I thank the committee for having this hearing today. I'm very glad that we were able to get the Improving Broadband Access for Veterans Act into the omnibus bill, and I say this is an important piece of legislation that will set us on a path toward closing the digital divide for veterans. I'd like to thank my colleague, Mr. Kinzinger, for working with me on the bill. One of the bills before us today would help further achieve the critical goal of closing the digital divide by setting targets for building out high-speed broadband in rural America, very important in my district. Another bill before us would help Americans, including veterans, when they are in crisis. I'm glad these common sense proposals are before us today. However, I have a concern about one of the bills, the Small Entity Regulatory Relief Opportunity Act. While I'm very open to finding ways to streamline compliance for small businesses, I'm troubled by the larger trend we are witnessing of protections across the board being eliminated. I'm very concerned that this bill will be another step backwards for consumer protection. And with that, I'll yield back to the ranking member and to the committee.
Gentleman yields back. This concludes our member opening statements. Members are reminded that all opening statements are made a part of the record. At this time, I want to welcome our witnesses and give them the opportunity for their opening statements, which will be followed by a round of questions. We are welcoming Mr. Tim Donovan, Vice President of Legislative Affairs at the Competitive Carriers Association, Mr. David Donovan, President and Executive Director of the New York State Broadcasters Association, Mr. Robert Gessner, President of MCTV, Mr. John Madigan, Vice President and Chief Public Policy Officer of the American Foundation for Suicide Preventions, and Ms. Sarah Morris, Director of Open Internet Policy at the Open Technology Institute at the New America Foundation. We appreciate that you are each here today. We will begin today with you, Mr. Tim Donovan, and you are recognized for 5 minutes for your opening statement.
Thank you. Chairman Blackburn, Ranking Member Doyle, and members of the subcommittee, thank you for inviting me to testify on meeting Congress's mandate for universal service and policies that will help close the digital divide for mobile connectivity between urban and rural areas. I'm here on behalf of CCA, representing nearly 100 wireless carriers, as well as the companies that make up the wireless ecosystem. All CCA members have an interest in closing the digital divide, and the vast majority of CCA members employ the same consumers that live and work in their communities. I thank the subcommittee for steadfast efforts to preserve and expand mobile broadband nationwide. We support several committee initiatives included in the Consolidated Appropriations Act and thank the leadership, members, and staff for their hard work and long hours to make that happen. Today, I will focus primarily on H.R. 2903, the Rural Reasonable and Comparable Wireless Access Act of 2017. While the title is a mouthful, the underlying issue is critically important, making sure that rural America has the same opportunities as urban areas, from economic growth and jobs to public safety, health, and education, because of access to robust mobile broadband services. CCA thanks Representatives McKinley, Welch, and their 9 bipartisan co-sponsors for focusing on this important issue. Universal service is not only a good policy objective, it is the law. Congress was clear in its mandate to the FCC to ensure that all consumers have access to reasonably comparable services as those provided in urban areas. H.R. 2903 will provide important transparency into whether the FCC is meeting the universal service mandate or if work remains by having the FCC promulgate regulations to determine whether services available in rural areas are reasonably comparable to those in urban areas. This committee has been hard at work on addressing issues necessary to expand broadband and pave the way to 5G. CCA supports those efforts. While 5G promises to support services that were once considered science fiction, we cannot neglect Americans living in areas that lack service. We need not look far to see how H.R. 2903 will immediately support the FCC in its USF mission. The FCC recently released a map depicting areas initially deemed eligible for Mobility Fund Phase 2 support. Because the technical parameters selected by the FCC were not sufficient to produce a map that reflects the experience you have as you travel your districts, significant portions of your states may not be eligible for funding through the Mobility Fund. It is now clear that standardizing data, as directed in the House-passed Rural Wireless Access Act as part of Ray-Baum's Act, is not enough to produce an accurate map if the standard is not sufficiently calibrated to meet the goal of the program. Final maps for eligible areas must reflect the statute's call for reasonably comparable services. Further, without a set standard, it is not clear that resources allocated by the FCC are sufficient. Without a goal, it is not possible to set a budget. H.R. 2903 will help guide funding levels necessary to achieve universal service. Other important policy decisions also rest on comparable service, including access to spectrum and streamlined deployment of infrastructure. Any evidence that rural Americans do not enjoy comparable services as their urban peers should reinvigorate the need for policymakers to take steps to support deployment. For example, spectrum is a finite resource, and all carriers must have access to low, mid, and high-band spectrum to deploy next-generation mobile broadband, whether in urban or rural areas. It is necessary to make additional spectrum available for all carriers to provide rural areas with the latest services, and Congress should first complete the 600 megahertz repack as safely, swiftly, and efficiently as possible to allow winning bidders to put the spectrum to use to serve consumers. And second, auction all available millimeter wave bands as soon as possible. I thank Representatives Lance, Doyle, and a dozen bipartisan co-sponsors for their leadership on setting timelines to auction this spectrum in the Airwaves Act and creating a fund from auction proceeds to support deployment in rural areas. This makes the bill a win-win for rural America. Carriers cannot provide comparable services without comparable infrastructure, and any challenges with cost, delays, or permitting are magnified in areas with sparse populations. The goals of H.R. 2903 again demonstrate how important efforts from the FCC and Congress are to support deployment. Separately, CCA appreciates H.R. 3787, sponsored by Representatives Latta and Schrader, also under consideration today. Smaller carriers already must overcome challenges larger carriers take for granted, and any appropriate regulatory relief Congress can provide will allow them to marshal resources to better serve their customers. With Congress, the FCC, and the administration all focused on closing the digital divide, the time to act is now, and H.R. 2903 provides a yardstick to measure where efforts remain necessary to make sure that rural America is not left behind. CCA looks forward with you to making the promise of reasonably comparable services a reality as access to mobile broadband becomes even more essential for modern life. Thank you again for holding today's hearing, and I welcome any questions.
Thank the gentleman. Mr. Donovan, you're recognized for 5 minutes.
On behalf of the New York State Broadcasters Association and along with the National Association of Broadcasters, I am honored to support the Pirate Act. Let me start by thanking Congressman Leonard Lance and Congressman Paul Tonko for their leadership in drafting this legislation. I also want to thank Congressman Chris Collins, who's been a leader on this issue for several years. But before I begin, I also want to thank the committee for their work in helping to secure repacking funding, which is in today's omnibus, and I truly want to thank you for all your work in that, and also Congressman Pallone for his work in the Sandy Act. FCC Chairman Pai and Commissioner Mike O'Reilly have made pirate enforcement a priority, and I want to recognize Rosemary Harold, who works in the Enforcement Bureau, and her team for her efforts. They are in the front lines, and their work is essential. But despite these efforts, it's become clear that the FCC needs additional tools to combat this problem, and the Pirate Act provides those tools. There are hundreds of illegal stations transmitting from balconies and rooftops of residential and commercial buildings across New York City and northern New Jersey. There are more illegal stations in the New York metropolitan area than there are legally licensed stations. And the problem is growing. It is spreading to Boston, it is spreading to Connecticut, and it is spreading throughout the United States. Pirates disrupt the emergency alert system. Their interference prevents listeners from hearing life-saving information broadcast by legal stations. Pirates do not participate in the EAS system, so consumers listening to these stations will not hear EAS messages. But more importantly, they undermine the basic fabric of the entire EAS system, which is premised on one station monitoring another station and so on down the line, similar to a row of dominoes. Pirate interference breaks this chain, which means stations who are relying on the EAS messages and consumers listening to those EAS messages will not hear them. Moreover, in the event of emergency, whether it's local news or public affairs, that life-saving information consumers won't hear because of pirate interference. Pirates threaten public health. Their transmitters operate and they threaten the health of unsuspecting citizens to RF frequency radiation. Let me provide you just with a few examples from our engineering analysis in 2016. You have slides before you, and they're also appearing on the board. What you see before you are pictures of illegal pirate radio stations operating in New Jersey and in New York. But the critical issue here of why I want you to see these stations is because none of these stations comply with FCC and government RF radiation standards. They are broadcasting at power levels between 10 and 3,000 watts. And if you look at the slides, included in there is how close you should be to these pirate antennas. And as a result, there are folks who are receiving above government standard levels of RF radiation that can range from 20 to 80 feet. Now, in the last slide, I will also notice it's right next to the East Orange, New Jersey police station, which we found ironic. But the bottom line is that if you live in the top floors of these buildings, or if you use a rooftop deck, you are being exposed to levels that are above government standards. And this is occurring in communities throughout New York, throughout New Jersey. They're occurring in, we had pirates in Albany, you're seeing them in Connecticut, you're seeing them in Boston. This requires, we believe, action. But pirates also interfere with airport communications on frequencies assigned to the FAA, creating an extremely dangerous situation. They ignore all consumer protections laws, whether it's sponsorship ID laws, indecency, public file requirements, alcohol and tobacco advertising laws. They have absolutely flouted all FCC political rules and regulations, whether it's access to candidates, equal time. All the rules that have been set down by the Federal Communications Commission are flatly ignored. The Pirate Act solves this problem. It gives the FCC additional tools. It significantly increases the fines for operating an illegal station. It clarifies existing law with regarding liability for those who facilitate pirates. It also provides working with state laws and recognizes those state laws, and it streamlines the FCC's enforcement process. In conclusion, in 2015, 33 members of Congress asked the FCC to increase pirate radio enforcement. The FCC, under Chairman Pai, have done that, but they need more tools. The fundamental purpose of the FCC is to manage spectrum and avoid interference. I thank you and look forward to your questions.
Gentleman yells back. Mr. Gessner, 5 minutes.
Good morning. Good morning. Chairman Blackburn, Ranking Member Doyle, members of the subcommittee. My name is Robert Gessner. I'm president of Massillon Cable TV, a small, family-owned broadband and cable company serving 50,000 customers in 5 Ohio counties. I'm also really nervous, as this is my first time testifying in any sort of venue. I also currently serve as chairman of the American Cable Association, which represents more than 700 small and mid-sized companies, a mixture of municipalities, telephone companies, electric companies, rural co-ops, as well as cable TV operators. The majority of ACA members have fewer than 1,000 customers, fewer than 10 employees, and almost none have an attorney on staff. Despite our small size, we make large investments in our networks to provide critical connectivity to the communities we serve, typically rural communities. And I thank you for inviting me to testify about H.R. 3787, the Small Entity Regulatory Relief Opportunity Act, or SARO. SARO is a narrowly tailored bipartisan bill whose purpose is to streamline the process by which deserving small communications entities may request, and I stress that word request, regulatory relief. Many regulations at the FCC are one size fits all. Because of our limited size, small entities often are not the source of the specific harms that the FCC is targeting. Now, in theory, the FCC waiver process gives small entities an opportunity to show good cause for an exemption or a delay in the application of a one-size-fits-all rule. But in practice, deserving small entities are deterred from seeking relief because of the administrative costs and the uncertainty of the waiver process. To give you just one example, in 2010, my company, which had recently converted to an all-digital platform, went to considerable expense to petition the FCC for a waiver of certain analog-based technical performance testing requirements. It was not until last September, more than 7 years after we filed our waiver request, that the FCC finally addressed our concerns. Now, the goal of SARO is to ensure that the FCC is more attentive to small entities' well-founded need for exceptions to or relief from one-size-fits-all rules. And it accomplishes that in 3 provisions. First, SARO directs the FCC to adopt streamlined provisions to reduce the administrative burdens faced by small entities that file waiver petitions and to expedite the resolution of those petitions. Second, SARO clarifies that Congress intends for the FCC, as part of its mandated triennial review process, to consider the impact of its rules on any and all small entities within its jurisdiction. SARO further instructs the FCC to modify or repeal the application of particular regulations to small entities where the Commission determines there is good cause to do so. And third, SARO establishes an automatic deferral period of at least 1 year in the application of most new regulations to small entities, subject to exceptions for rules that address public safety concerns or that reduce waste, fraud, and abuse. If SARO had been in place in 2010, my company would not have been subjected to 7 years of regulatory uncertainty waiting for the FCC to act on our petition. In fact, we might not have needed to go to the expense of filing the petition in the first place. Now, I want to stress that SARO is focused only on the procedures by which small entities can request regulatory relief. That's the O in SARO, an opportunity. Nothing in the bill would change the substantive legal standard for obtaining that relief. And I also want to emphasize that while I'm here representing the American Cable Association, SARO is not a cable-only bill. SARO will apply to and has the support of small entities in every sector of the communications industry, as evidenced by this letter that was sent to Chairman Walden. So in conclusion, I do want to express my thanks to Representatives Latta and the absent Mr. Schrader to move SARO forward. As Representative Latta stated in his introduction, while small businesses are the engines of the economy, generating 2 out of 3 new jobs, they also are the most susceptible to burdensome regulations that harm their ability to grow, expand, and hire employees. ACA looks forward to working with you on this sensible and important piece of bipartisan procedural regulatory legislation. I'll be happy to answer any questions. Thank you.
Gentleman yields back. Mr. Madigan, 5 minutes.
Madam Chairman and Ranking Member Doyle, thank you very much for inviting the American Foundation for Suicide Prevention to testify this morning. My name is John Madigan. I have the honor and privilege of being the association's Chief Public Policy Officer. We are a nonprofit health agency, about 30 years old, and we're organized in all 50 states. And I believe my team has provided all members of the subcommittee with fact sheets that illustrate the suicide issue in your particular state. I am also here to testify about H.R. 2345, the National Suicide Prevention Hotline Improvement Act of 2017. We want to thank, obviously, Representative Chris Stewart from Utah and Representative Eddie Bernice Johnson from Texas for their leadership on this important issue, and the other co-sponsors in the House, which is somewhere around 70 co-sponsors. Let me speak frankly. Suicide is now the 10th leading cause of death in our country for adults age 18 to 64. For every one suicide, there are 25 suicide attempts. The annual age-adjusted suicide rate is 13.42 per 100,000 individuals. After adjusting differences in age and sex, risk for suicide is 19% higher for male veterans than for U.S. non-veteran male adults. Risk is 2.5 times higher among veterans when compared to U.S. non-veteran women. Men die by suicide 3.5 times more than women, and white males account for 7 out of 10 deaths in 2016. Suicide is often the result of unrecognized and untreated mental illness. Get this, 1 in 4 Americans have a diagnosable mental illness, but only 1 in 5 are seeking professional help for this condition. Suicide tends to be the highest when multiple risk factors or precipitating events occur in an individual's mental illness. Despite public perception, most people with mental illness do not die by suicide. Mental illnesses such as depression, bipolar disorder, alcohol and drug dependence, post-traumatic stress, and traumatic brain injury may create the underlying risk that when combined with life stressors, such as transition from military life, job loss, relationships, financial or legal problems, increase risk. There's good news. There's a grassroots movement that's now being formed, like it has for many other disease groups. Our movement's being catalyzed by both survivors of suicide loss. I lost my younger sister, Nancy, 20 years ago when she was 37. And so the emerging voices of those that have what we call the lived experience, those people who have survived their own suicide attempts. So as I said earlier, I'm here today to talk about why H.R. 2345 could be a game changer for our national public net. It was discussed by Chairman Pallone. Essentially, the FCC is going to look into the possibility of converting the 1-800-273-TALK number into an easy-to-remember 3-digit number like 911. It will require SAMHSA to study the effectiveness of the current system and also to assess how veterans are being helped in this system. Finally, the study will provide cost estimates and resource needs for increasing federal support for phone hotline, chat, and text. So here are some important facts. A national, easy-to-remember, single-point access, free, anonymous, and toll-free for all American residents is necessary to provide a health safety net for all persons in the United States. The experience of SAMHSA's National Suicide Prevention Lifeline indicates that a national hotline number has been essential in addressing this public health crisis. Since 2005, the Lifeline has served more than 11 million callers. In 2017, the national network answered 2 million calls. According to independent evaluators of this service, 75% are non-suicidal and 20% are suicidal. So the bottom line in closing is that this legislation is critically important. When my 25-year-old daughter texted me this morning and asked me, "Daddy, why are you testifying before the Communications and Technology Committee?" I said, preventing suicide's all about communication, and in the 21st century, all about technology. So I'll be glad to answer any questions you have.
We thank the gentleman. Ms. Morris, you're recognized for 5 minutes.
Thank you, Chairman Blackburn, Ranking Member Doyle, and subcommittee members for the opportunity to testify today at this legislative hearing on 4 communications bills. My name is Sarah Repes, Open Technology Institute, or OTI, and the Open Internet Policy. New America is a nonpartisan, nonprofit civic enterprise dedicated to the renewal of American politics, prosperity, and purpose in the digital age. OTI is a program within New America that works at the intersection of technology and policy to ensure that every community has equitable access to digital technology and its benefits. OTI promotes universal access to communications technologies that are both open and secure, using a multidisciplinary approach that brings together advocates, researchers, organizers, and innovators. Our primary focus areas include net neutrality, broadband access and adoption, surveillance security, and consumer privacy. My testimony will focus on concerns related to one of the 4 bills under consideration today, H.R. 3787, or the Small Entity Regulatory Relief Act, which I will refer to as SARO. OTI's concerns are fourfold. First, it is not clear that an immediate problem exists that this bill would effectively solve. Indeed, against the backdrop of the current heavily deregulated landscape, the proposed bill seems particularly unnecessary. Second, to the extent that a need for waivers from or exemptions to certain regulations exists, numerous processes for securing them also already exist at the Federal Communications Commission. Third, the definition of small entities in the bill is unclear. Finally, the proposed triennial review process reforms would create a high degree of confusion and uncertainty at the Commission. I've submitted detailed written testimony to the subcommittee already, and I will use my time here to briefly explain each of those 4 concerns. Regulations of general applicability are the standard in federal regulatory policymaking, and for good reason. The point of consumer protection laws, from telecommunications to food service to healthcare, is to protect all consumers from harmful practices, not just consumers of the biggest entities. All consumers are entitled to the protections of federal telecommunications laws. There may be instances where waivers from certain regulations under the Communication Act are appropriate. As I will discuss shortly, there are mechanisms for addressing the need for specific waivers. However, neither Mr. Gessner nor the bill's co-sponsors have demonstrated widespread and significant harms that would be most effectively remedied by the reforms proposed in SARO. It is unclear why the triple play proposed in the bill, an expedited waiver application process, a near blanket exemption from all future regulations for a period of 1 year, and an expanded triennial review of the applicability of all regulations to small entities is necessary. Indeed, the Commission already provides numerous avenues of recourse for a small business that believes an existing or proposed regulation is unduly burdensome. The most obvious and fundamental opportunity to discuss burdens on small businesses is to engage with the Commission during the notice and comment periods that are required each time new rules are created. In those proceedings, the Commission has opportunities to hear from multiple perspectives on the party's assertion of burdens and can appropriately weigh those burdens with the need for the regulations in question. In addition, as the bill itself acknowledges, the Commission's rules already allow the Commission to waive specific requirements of the rules on its own motion or upon request. The best approach for ensuring certainty and reducing administrative burdens is to use existing processes to identify the need for narrow, cabined grants of waivers when a need for such a waiver is clearly demonstrated. This bill, however, uses an arbitrary definition of small entity that creates considerable confusion and shifts the burden of defending the general applicability of a given regulation onto consumer groups and other parties every single time a regulation is considered. Not only is this a significant administrative cost to bear on its face, the problem is compounded by the fact that the 2% market share threshold will need to be defined every single time a regulation is considered. As we have seen in antitrust analysis, this type of market share definition is entirely dependent on how a given market is defined. As telecom industries become more integrated and services evolve, defining relevant market could become even more difficult. Finally, the modifications to the 257 triennial review requirement proposed in this bill could create significant administrative burdens for consumer groups and other parties. As written, the amendments to 257 would allow the Commission to, once a bill is enacted, relitigate every single regulation currently on the books at the Commission. This reevaluation would require multiple proceedings to be reopened and create enormous bureaucratic strain throughout the communications bar, as well as uncertainty for consumers. Each of the 3 proposals in SARO raised concerns. Taken together, however, they represent a fundamental shift in burdens and advocacy before the Federal Communications Commission. I urge the subcommittee to reject H.R. 3787.
gentlelady concludes her statement. At this time, that concludes all of our opening statements. We're going to move to questions. I do want everyone to be mindful. It looks like 12:15 to 12:30 will be the next vote series, and I want to move through as many of these questions as we can. So, Mr. Shimkus, I will begin with you. You're recognized for 5 minutes for questions.
Madam Chair, thank you. You're very kind. Let me go to Tim, and I want to ask Mr. Gessner this question because I've just been wrestling with it. So we want competition, we want deployment. You're in the rural areas, very difficult. You're trying to get 5G in. I keep hearing from my local municipalities a concern that their input as to siting for 5G, they're not going to, they'll weave a story. We got this great park. We don't want a refrigerator-sized 5G thing sitting in there. So talk me through this on competition, 5G, and how do we make sure that the concerns of local communities are still at least listened to? Because a lot of this is these regulatory burdens, get it moved, right?
Yeah, thank you, Congressman. And you're probably also hearing from them about how they want to be one of the first smart cities and want to make sure that all of your constituents are able to connect to the latest services. So you do need to have the infrastructure to provide that. We're working together with ways to look at it not as a zero-sum game, but how can we make the application process both easier for carriers who are deploying this, as well as reduce the resources needed by municipalities to review. If there's some low-hanging fruit of places that make sense to streamline the review, then that also means one less application, a couple hours that somebody who works for the municipality has to spend reviewing that application.
So, Mr. Gessner, obviously from the rural cable perspective, there will also could be, debates. You've already done negotiations with local communities on right-of-ways and wires. And talk to me about the competitive pressure, or what would be your response, as there is a great desire to also move 5G into areas, and local communities have been able to. The old historic model is what? The historic model is the cable company comes in, they negotiate, there's fees, they work with the local communities. 5G could disrupt the way this paradigm has been established, but a lot of us want the competition. So can you do that from your perspective?
Good question. We haven't had a great deal of interaction between the 5G proponents and traditional cable companies, at least not in our size markets. We look forward actually to working with the 5G operators because we know they're going to need a lot of backhaul. When you've got a 5G transmitter every few hundred feet, it has to connect to something. So companies like mine are certainly prepared to work with them through our high-capacity fiber networks to bring all of that 5G data back without having to have more repeater towers and that sort of thing.
Great, and I was going to spend time asking you to talk about some of the other challenges and problems you have, but in lieu of the time, Madam Chair, and everybody else want to ask a question, I'll yield back.
Gentleman yields back. Mr. Doyle, 5 minutes.
Thank you, Madam Chair. Under the Regulatory Flexibility Act, Congress created an independent office of advocacy within the Small Business Administration. The job of that office is to go out and advocate before Congress, the White House, and federal agencies on behalf of small businesses in America. The Office of Advocacy has come on against regulation that harms small businesses, like the FCC's order to deregulate business data services. Much like the FCC's rollback of business data protections, I'm worried that this small entity bill would actually hurt small businesses. I want to ask you, Ms. Morse, do you believe that H.R. 3787 could unfairly disadvantage some small businesses over others?
Sure. Thank you, thank you, Ranking Member, for the question. And I certainly think that there is a high risk of harm to all types of entities, whether it's consumers, and consumers can include small businesses that are purchasing broadband from an entity that would be covered by this act. In the case of the net neutrality protections, where a waiver was granted for certain parts of the rules, A more automatic and sweeping waiver in that case would have resulted in many small businesses that rely on an open internet access to be harmed by the lack of that access in certain instances. We want all consumers to have access to the protections afforded by the Commission, not just those of the largest entities.
So let me ask you, under this bill, the threshold for expedited small business relief is set at 2% or fewer of the consumers receiving such subscription service in the United States. It seems like a vague standard, but also a rather overly inclusive one as well. In the video market, for example, 2% of the market would be over 1.6 million customers. And when you look at a couple of companies that fall into that range, they have annual revenues of over $1.5 billion. That doesn't seem like a small business to me. Does that seem small to you? And what effect would exempting these companies from the FCC's rules have on consumers?
We certainly agree that the definition is both unclear and potentially much too large. And as you point out, Ranking Member Doyle, this implementation of this bill has the potential to remove protections from millions of Americans across the country, protections that the FCC would have otherwise deemed necessary in a thorough rulemaking process.
Yeah, I think more to the point, the FCC interacts with a wide range of small businesses, from radio and TV stations, voice, video, data providers, device manufacturers, wireless licensees, and many of the FCC's rules that these businesses comply with are not only tailored to the size of those businesses, but also to ensuring that these entities uphold their obligations under the Communications Acts. So what effect would granting these wide-ranging waivers have on industry sectors under the FCC's jurisdiction?
We think it would create significant uncertainty as we try to figure out which regulations apply to which entities, which ones apply to other or don't apply to other entities. And meanwhile, I'll just repeat that consumers in those industries will be harmed in the process when those protections don't apply to their providers.
Thank you. Madam Chair, in the interest of time, I'll yield back.
Gentleman yields back. Mr. Lance, 5 minutes.
Thank you, Madam Chair. To the distinguished panel, thank you all for being here. Mr. Donovan, can you comment on some of the limitations of the FCC's current enforcement tools against pirate radios? Have you seen issues with the Commission's ability to shut down pirates in your role as president of New York Broadcasters?
Thank you, Congressman Lance. Yes, I think that there are some limitations, and those limitations now are based in the statute. Let me give you some examples. Under the Communications Act, the fine, for example, for an entity not licensed by the FCC is roughly $10,000. Pirate radio operators, this is big business, and a $10,000 fine is absolutely nothing. When you actually look at someone who's been violating the law literally for decades, this is just the cost of doing business. The second piece is that in order to get a seizure order or in order to enforce the fine, the FCC is required to go through the U.S. Attorney's Office. They are busy on things like terrorism, drug interdiction, and this becomes the fourth level issue. What I think, and I worked at the Commission for 10 years, I think what we really need to do is to give the FCC the authority to go to court, to defend its own orders, and also to get seizure orders as well. The FCC currently has the authority to go to the U.S. Court of Appeals to defend its orders at the appellate level. It seemed it would make sense to get rid of the number one issue, which is, would love to help you, but the U.S. Attorney's Office just isn't interested.
Thank you. I'm working on this issue, as you know, under
Yes.
the Pirate Act, and I want to continue to work with you and the other distinguished members of the panel, and I certainly agree with you. And, Madam Chair, I ask unanimous consent to submit the New York Broadcasters Report on pirate radio into the record.
Without objection.
Thank you, and I yield back 3 minutes.
Gentleman yields back. Ms. Matsui, you're recognized.
Thank you very much, Madam Chairman. Since its creation in 2004, the Spectrum Relocation Fund has become a critical tool for federal agencies relocating or sharing spectrum for wireless broadband use. In 2015, Congress made improvements to the SRF that allowed agencies to use funds in the SRF to support engineering research that could lead to the repurposing of spectrum for commercial use. The improvements have worked. Last month, NTIA and DoD identified 100 megahertz of spectrum that could potentially be repurposed. However, current law limits how much of existing SRF funds can be used for this research and related activities. This has created an unintended situation that could prevent agencies from accessing existing SRF funds and potentially prevent more spectrum entering the commercial marketplace. I'm working on legislation called the Spectrum Now Act to address this problem. Mr. Donovan, that's Tim, would you support this effort to ensure they were maximizing the amount of spectrum that could be repurposed for wireless broadband use?
Thank you, Congressman, and thank you for your leadership on these efforts. I think it's a proven case model that it works in working with Spectrum Relocation Fund to reallocate federal spectrum for commercial use. Your leadership on that issue led to the single highest grossing spectrum auction ever, AWS-3 auction. So this money is clearly well spent. We absolutely support your efforts to continue that. Spectrum is something that we're not making any more of it. So if we can be more efficient, then that research is money well spent.
Okay, thank you. To successfully expand broadband access to the rural and remote areas of this country, broadband maps must accurately identify where service is and where it isn't. One of the most effective ways to get better maps is by collecting better standardized coverage data. I understand that a consensus proposal to get better mobile wireless coverage data was put forward as part of the Mobility Fund 2 challenge process. Specifically, that proposal suggested modeling 4G LTE coverage at download speeds of 5 megahertz per second at a 90% cell edge probability under a cell loading factor of 50%. Mr. Donovan, Tim again, how can accurately modeling mobile broadband data help expand coverage?
Thank you. And this has been an important issue going on making sure that we know where there is service and where there isn't so that we can direct funding where it's appropriate. One thing that is missing from that model that's included in Congressman McKinley and Congressman Welch's bill is also looking at signal strength. And while it gets technical quickly, it's important. We measure signal strength in decibel milliwatt loss, but a difference of only 5 leads to a difference of about 100% geographic coverage. In rural areas, a difference of 10 leads to about 300% geographic coverage. When you look at that, while there was consensus to move forward before, the factors selected by the FCC produced this map that we now know from looking at it that it doesn't pass the test that you all know from your travels across your states, that it's not the experience that your consumers are receiving.
Okay, well, thank you very much, and I yield back the remainder of my time.
Gentlelady yields back. Mr. Latta, you're recognized for 5 minutes.
Well, thank you, Madam Chair. And Mr. Gessner, when I travel around my district and meet with a lot of my business owners, especially the smaller business owners, they talk about the overregulation that's occurring, especially on the federal side. And then also how that regulation affects your business. And also a lot of times as legislators and then the regulators, they don't really see the after effect of what happens. And I was wondering if you might be able to look as a small business owner and also in telecommunications, if you can think of some real-world examples where Sero could have helped your business and consequently your customers.
Thank you. Thank you for the question. I offered a brief explanation of my situation in 2010 during my testimony. I'll expand on it a little bit. We converted from an analog cable system to an all-digital system in 2010. We thought that was the right thing to do. We were well before everybody else, and we went along with the broadcasters at the same time. Shortly thereafter, we realized that we could no longer complete analog testing as required by the FCC because we had no analog signals to test. So we requested a waiver from analog testing, and it should have been very, very easy because there had already been one operator who had received a waiver from analog testing. So we thought, just give me one of those. So we went to the expense, we went to the time, produced the affidavits and all that sort of thing. And there were several, maybe a half a dozen of us who were doing the same thing at the same time. Radio silence. We didn't hear anything for 7 years. And what finally happened was the FCC changed the rules and told all of us that our petitions were moot. Now, if Sero had been in effect then, we could have been spared those 7 years of regulatory uncertainty. If Sero had been in place then, the FCC would have been through at least 2 triennial reviews and had recognized that Analog testing by digital systems was something that had to be addressed, and they could have addressed it, and no waivers would have been, no waiver petitions would have been required in the first place.
Well, thank you very much, Madam Chair, and I'll yield back the balance of my time.
Gentleman yields back. Ms. Eshoo, you're recognized.
Thank you, Madam Chairwoman, and thank you to each of the witnesses. It's good to see you, and I think that you all did a good job in presenting what you want to present. To Ms. Morris, in your written testimony, you noted that the small entity bill, 3787, is vague in its definition of a small entity. Now, some entities may have very few subscribers, in the thousands, but the language also applies to companies with millions of subscribers. And I wouldn't consider millions of subscribers as small. If this were to become law, first of all, I think it's an ambiguous definition, obviously, because millions is not small. So if this were to become law, what's the outcome of this? What would actually take place?
Thank you, Congresswoman Eshoo. I appreciate the question. And on this this issue of the definition of small entities, I would note that the bill may seem like it clearly and cleanly defines what a small entity is, but it creates worry that gamesmanship could be used to sort of water down the definition, and that can change over time and be very costly and complicated to determine on a recurring basis. And because, as you point out, that the range of potential entities covered in the definition is so expansive, as I noted earlier, we risk disenfranchising millions of consumers from the important consumer protections that the Commission determines that they need once they're enacted.
Because tied to this are what you just described, correct?
Yes, essentially what this bill would do would be every time the Commission makes a determination that a regulation is needed at a general level, what would be otherwise a regulation of general applicability, that there would be essentially an automatic waiver for a year's time for small entities as defined broadly in the Act. And so for that period of time, those customers and consumers would be would not have access to the protections afforded to those who are customers of larger companies.
Well, I think that that this is an area of this bill that really needs to be tightened up, because otherwise it can swing one way or another. One day it could be determined that small is in the thousands, and waivers can be granted for those that have millions. It just doesn't, it would have been better if they just said waive everything, because that seems to be the intent. In your testimony, you also said, quote, "The point of consumer protection laws is to protect consumers from all harmful practices, not just those from the biggest entities." It seems to me that this is a Trojan horse, because it's going to hamstring the FCC's ability to do the job that's been laid out relative to the protection of consumers. Again, small companies would not have to play by the rules that everyone else has to play by in terms of how it's defined or not defined in the language of the bill. Can you describe if there's an alternative to burden? Is there significant consumer risk there as well?
I'm sorry, if there's an alternative burden, if a new burden is placed on, I think that, there is the sort of immediate risk of what happens when the one-year waiver is in place. I think that there's also a concern that this will just overly complicate rulemaking processes at the FCC. We're going to have to pre-litigate what counts as a small entity in every proceeding. We'll probably have to litigate after the fact as well. And meanwhile, there will be less focus on the making sure that we get the rules right so that they don't create the types of situations that Mr.
Well, I
Gessner
think that there's always a legitimate a case to be made for streamlining, but I think that this is going to turn into a hairball. I really do. I would just suggest to the authors that they tighten up the language, because the definition is so wide, a Peterbilt truck can drive through it. Thank you.
All right, Lady yells back, and if everyone, I'm told, can try to keep it 3 minutes or less, we should be able to dismiss our panel before we go for votes. Mr. Olson, you're recognized.
I thank the chair. Welcome to our 4 witnesses, 5 witnesses. My comments and questions are for you, Mr. Madigan, on suicide and HR 2345. Like you, suicide has hit me directly as a congressman and even in my family. In 2014, a Marine veteran, Casey Owens, killed himself in Colorado. He was 32 years old. I met Casey in 2007 in our hometown of Sugar Land, Texas. He had lost both legs, PTSD, TBI, when a small Humvee hit a tank mine. The thing flew up 30 feet in the air. He found peace in Colorado skiing, snow skiing. He was a competitive mono skier. His goal was to ski for our country in the Paralympics. But he never found true peace. He was on CBS News in 2012, and he responded this way, quote, "I really don't think I'll ever be free. I don't think the burden of war is ever gone," end quote. And sadly, it wasn't. And now my family. When I was in high school, my mom got a master's in family therapy for kids. She met a 13-year-old little girl named Sherry Silvas at the Harris County Youth Village. Sherry had been abused by her father. Her mom was worthless. She was into gangs, drugs, and she also had a natural chemical imbalance. All those came together to make her regularly think about committing suicide. Mom became very close to Sherry. In fact, she became a de facto 4th child in my family. But she was a handful. She disappeared for 3 months. My dad found her halfway across the country. He brought her back. But 2 years after that, Sherry took her own life as well. My mom, my dad, and my entire family are still haunted. We couldn't stop her from taking her own life. And in your testimony, your written testimony, you said that having a verbal counselor, a line to call a person, is so effective. It actually reduces suicides and the feeling of hopelessness. Would that have helped Sherry, and how important is that number to have, that 311 number?
Well, Congressman, first of all, I'm sorry for all your experiences, and I hope you find some closure and peace. And I think the legislation that we're looking at today is one piece of the puzzle, in that the data that we have, 25% of the callers have some suicidal ideation, so they do get immediate help in terms of talking out what is currently going on. Clearly, with veterans, there's a whole host of, as I described in my oral statement, but in more detail in my written statement, the life stressors that then set off a pre-existing mental health condition. So that's the bottom line, is that we, as a nation, need to more quickly recognize someone's mental illness situation, much like you would someone having a diabetic attack or having heart disease. And then I love to talk about the fact when you go ask a 5-year-old, what's the biggest organ in the body? And they normally say the heart. And I say, well, wrong. The biggest organ in the body is the brain. And if your heart's broken, you go to the heart doctor to get it fixed. If your brain's broken, you need to go to the brain doctor. So it's part of that process, and we believe a 3-digit number would make access for counseling more readily available.
And hopefully DOD could use that three-digit number, because there's been a report by JO that says, hey, you guys are overwhelmed by some calls. People aren't getting the therapy they need via phone calls. So hopefully this helps them, gives them a chance to get to guys like Casey.
Yes, the phone calls from this January to now versus January last year have increased 60%. So the need is clearly there, sir.
I'm sorry if you lost as well. Madam Chairman, I yield back.
Gentleman yields back. Mr. McNerney, you're recognized.
I thank the chair. As I mentioned earlier in my opening statement, I'm concerned about the larger trend we're seeing with consumer protections across the board being eliminated for my constituents. Ms. Morris, what protections do consumers currently have with respect to their online privacy and the information they share with their broadband provider?
None. None from the Federal Communications Commission. They were repealed.
Okay. What protections do consumers have with respect to their broadband provider keeping their data secure?
I do less data security work, but I would imagine very little, because the work I did was in the broadband privacy.
Okay. Well, what about respect to consumers' access to information being online being throttled or blocked? Will there soon be any protections left for consumers from blocking and throttling?
Once the 2017 December order takes effect, no.
Well, I'm certainly open to finding ways to streamlining regulatory compliance for small business, but I'm worried that the Cero bill would move us further in the direction of eliminating safeguards for consumers, many of which have already been eliminated. Ms. Morris, in your written testimony, you stated that a triennial review process would create a high degree of confusion and possibly legal uncertainty at the Commission. Can you explain how a high degree of confusion at the Commission is likely to impact consumers?
Sure, and what I mean by that is that once the bill would take effect, there is the every 3 years the triennial review, but there's also the initial review when it seems like it would be essentially open season on any regulations in the FCC's currently on the books. There's no sort of limitation. It would be a retroactive review as far as I can tell from the text of the bill. So that would mean that what small protections remain for consumers in this deregulatory environment at the Commission would be under scrutiny once again, presumably with new proceedings opened to reconsider all of the application of all of those regulations, which could tie up the Commission's hands for months or years on end.
Thank you. Mr. Madigan, in written testimony your organization submitted, it was noted that veterans, in particular male veterans, are more often at risk of suicide. In my experience serving on the Veterans Affairs Committee, I found that veterans sometimes feel isolated when they return home. Do you think that's one of the contributing factors?
Absolutely. I mean, isolation, alcohol, access to guns, I mean, all those kinds of things are something that contribute to veterans completing suicide.
Good. Do you think that making sure veterans have access to 21st century infrastructure like broadband could help our veterans?
Well, as I said at the closing of my oral statement, I think, yeah, communication's the key. Talking about mental health issues like any other health issue, and if technology can be increased and broadened, I believe our organization believes that's the way to go.
Good. And I thank the chair, and I'll yield back.
Gentleman yields back. Mr. Bilirakis, and I remind everyone if we can keep it to 3 minutes, then we'll probably be able to gavel out. Mr. Bilirakis, your record.
Thank you, Madam Chair. Mr. Madigan, as Chairman of the Affairs Committee for many, I know the veterans are a uniquely situated population in their experiences and challenges. The last OIG report on the Veterans Crisis Line identified a number of problems, including a considerable volume of calls going to voicemail, which is unacceptable. Since some time has passed, I agree with the intent of H.R. 2345 to study how the needs of veterans are addressed by the National Suicide Prevention Hotline, the Lifeline. In your testimony, you say that 1 in 3 callers to the suicide hotline are veterans or members of the military families, because they suffer as well. Can you explain the unique challenges that these callers face? And in your position, have you seen specific issues related to a call responder's ability to address these needs through the hotline?
Sure.
And in other words, also some of the responders, are they veterans? Can they identify with a veteran?
Yes, that's a great question. When you call 1-800-273-TALK and press 1, you're immediately handed over to a peer-to-peer counseling service where veterans who have been through the same experiences that most callers have been through are there. So I think it's a awesome program. The budget needs to be increased. The number of counselors need to be increased. And clearly, with the fact that, sir, that we lose anywhere from 18 to 22 veterans a day that we know of.
That we know of,
That
exactly.
we know of,
Yeah.
correct. That's a major problem. So we're committed, again, that's why we support this legislation, to look at the whole picture, see what's working. But the bottom line, when Orrin Hatch called me last May to talk about this bill, I said, Senator, it's a great idea, but if you make it easier to call and there's no one there on the other end to answer the call, or that they're not competent to answer the call, then that's a big problem.
So a veteran can speak, a combat veteran can speak to a combat veteran.
Absolutely.
Is that correct? And this-
Yes, sir.
It was in
Yes.
a similar situation.
More and more, any of the veteran hotlines that I'm aware of employ peer-to-peer counselors, yes.
Okay, I'd like to speak with you on that.
Yeah, I
Maybe
can also
come
tell
by
you
my
about something,
office.
let's talk offline about
I'd like to help.
Vets for Warriors out of New Jersey, which is Rutgers University sponsors it, and it's upstream counseling of veterans. So before someone gets to a bridge or puts a gun in their mouth, it helps veterans when they might lose their home, they're having personal problems or financial problems.
Okay, I'm going to stick with the 3 minutes, but the three-digit number is obviously more, it's easier to remember
Yes.
as opposed to the 1-800 number. That's
Well, it's
correct. You found that.
1-800-273-TALK, but imagine you're in the middle of a
Yeah,
suicidal ideation, unless it's
Exactly.
written somewhere, it's hard to remember. So I even think a 5-year-old knows to dial 911 when they need to call the police. And we also think that having a dedicated number like 311 or whatever it might be
Right.
would reduce the burden on 911 and get people to the right location the first time.
Agreed. Thank you. I yield back, Madam Chair.
Gentleman yells back. Mr. Engel, you're recognized.
Thank you, Madam Chair. Mr. David Donovan, nice to see New
Yes,
Yorkers
Congressman.
here.
Good to see you again.
Welcome to Washington. I'm interested in the enforcement requirements of the Pirate Act.
Yes, sir.
You testified that pirate radio stations outnumbered licensed stations in some major markets, and as I understand it, the draft legislation in front of us today would require, and I quote it, sustained enforcement attention on pirate broadcasting, unquote, including a requirement that the FCC conduct pirate radio enforcement sweeps in some markets. So to your knowledge, has any agency, DOJ, FCC, or any other conducted regular pirate radio enforcement sweeps in the past? Do you have a sense for the amount of time, money, and personnel these sweeps would require?
To my knowledge, the Department of Justice has not done any sweeps. The FCC may have done one. In terms of time to do a sweep, for example, it took us 4 days to find 76 pirates in New York City and in northern New Jersey. So the actual amount of those sweeps does not take that amount of time. And in fact, with technology, you can actually reduce the amount of time that you need. For example, there are radios that are currently on the market that you connect to the internet, and you place them throughout New York City or northern New Jersey, and you can sit in the FCC's office in Washington or in New York and literally turn the dial, and you know what stations you've licensed, and you'll be able to hear what stations aren't licensed. That will tell you, depending on the location of where that radio is, that we know we have 30 pirates near Flatbush, or we have some in the Bronx. What it does is, by using technology in a smart way, will actually reduce the ability or reduce the burdens that are imposed by doing sweeps. But frankly, we've done sweeps. I've done 4 sweeps over the last several years, and again, I found 76 pirates in 4 days. So it's not, the burden of doing the spectrum sweep is really not, it can be done. And the FCC has the capability and equipment to do it. And sir, to be blunt, I would be more than happy to work with the Federal Communications Commission to help get those sweeps done.
Thank you. Ms. Morris, let me ask you a quick question. I think you point out something really important in your written testimony regarding the Small Entity Regulatory Bill. The Paperwork Reduction Act and the Regulatory Flexibility Act already requires the FCC to contemplate the effects of new protections on small businesses, and there is already a number of opportunities for small cable or phone companies to get waivers under the FCC's procedures. So in your view, are there too few avenues for small business to be accommodated in FCC proceedings?
It is my view that there are not too few, that there are sufficient avenues already at the FCC. I'm sympathetic to situations where a waiver, as in Mr. Gessner's case in his testimony, was not able to be achieved in a timely fashion. We would simply advocate for a more surgical solution to those specific problems rather than the blunt tools that would be employed under SARO.
Thank you, Madam Chair. I yield back my time.
Thank the gentleman. Mr. Johnson, you're recognized.
Thank
3
you, Madam
minutes.
Chairman. Mr. Gessner, first of all, thanks for what you do in your role as the president of Massillon Cable. You serve a large number of people in one of my counties of 18, so I appreciate that. I saw in your comments that you highlighted one example where the waiver process did not work in a timely fashion for you. Do you have other statistics or insights that you could share with us about that dynamic?
Thank you. Thank you for your question. Yes, I probably have 4 or 5 current examples that would probably be more anecdotal than anything else, but by way of description, I'd refer to a staff report that was issued to this committee in 2011, and it was entitled The Staff Report on Workload of the FCC. And part of their conclusion was, and I quote, "The Commission faces significant challenges in its work, including a significant backlog of unanswered petitions." And they went on to note that more than 5,300 petitions, which was 20% of the total petitions at that time, had been at the FCC for more than 2 years, and that more than 3,000 petitions had been pending before the FCC for more than 5 years. And that, I think it speaks volumes to the ability of small entities who don't have on-staff attorneys to keep after this process to see their petitions for needed relief through to a conclusion.
And to give our members and the American people some idea of what that means on the business side, I'm told that this cost can be up to $50,000 per year for a small company that, while they're awaiting resolution. So you got 5 years, that's 250 grand out of that small business. That's a big pot of money.
Correct. That came from a more recent petition request where a small telephone company applied for relief, and while it was granted in about 3 years, they estimated the cost to be about $50,000 a year, which for them is enough to hire another full-time associate to actually serve customers.
Yeah. Okay. Well, thank you. Mr. Donovan, Mr. McKinley and Mr. Welch's bill, H.R. 2903, embodies the spirit of our effort to close the digital divide between rural and urban areas. What kind of data is necessary to close this divide on wireless broadband coverage?
Thank you, Congressman. I think, as you know, that the data that's currently on hand is not reflecting the experience that you have. Your portion of Ohio on the map looks like it's covered with service. I think you've explained to me before how that's not the case.
We know that's not true.
So what the bill does is it takes a look at the services that are available in urban areas and uses that as a measuring stick to see what services should be available. With that in place, you can then collect data based on the experience that other Americans are having to make sure that there's services available to everyone.
All right. Well, thank you. I wish we had more time to talk about it, but I understand the need to yield. Thank you, Madam Chair.
I thank the gentleman for yielding. Ms. Brooks, for 3 minutes, please.
Thank you, Madam Chairwoman. I'm going to follow up on what my colleague from Ohio just talked about, Mr. Donovan. Let's go on and allow you to answer a bit with a bit more time. What kind of analysis does the FCC do as to whether or not its USF policies are meeting the goals of the program? And do we have information on how effective the USF program is in ensuring that comparable service that he just started to talk about?
Thank you, Congressman, and thank you for joining the bill as a co-sponsor. We appreciate the support. So right now, as Mr. Welch noted during his opening statement, there is no determination of what is reasonably comparable services. So the FCC collects data. They collect Form 477 data. They collected, in the case of Mobility Fund, a special one-time collection of data. but they're not then going back and applying any sort of report card over whether that's working, whether we're getting the job done. And so we're continuing to move forward, and as we're talking frequently about 5G, there are places in the country that don't have any G. We have a saying at CCA that you have to keep up with your Gs. And when you start falling behind on the digital divide, it gets harder and harder to catch up. That becomes even more important as so many different aspects of our society are connected.
Is it fair to say if we do resolve some of these issues involving the digital divide, whether it is the targeted support through the USF program and siting reform, access to spectrum, is it possible that those rural areas will jump to 5G?
Well, you just nailed the three-legged stool of infrastructure, spectrum, and USF. Those are all important to solving these problems in rural areas. And yes, so carriers that are now looking at making sure you get to 4G services, or looking at how you can layer on top of that at the same time the 5G services, whether it's through technology or using different spectrum bands to make sure that the same services are available in urban areas and rural areas.
Thank you. I'll yield back balance of my time. I know we're trying to get other members in. Thank you.
I thank the gentlelady. Mr. Collins, you're recognized.
Thank you, Madam Chair. My questions are directed to David Donovan. Thank you again for your testimony today on pirate radio. This bill is going to create a database of licensed radio operators. I call that a common sense kind of bill. I've been battling this for years, primarily with our former chair, Tom Wheeler, who frankly, as chair of the FCC, did not seem interested at all. I can assure you Ajit Pai, our new FCC chair, does take this seriously, to which I think we're going to see a big change. Obviously, these pirate radio operators are raising money. In some cases, we have advertisers who have no idea it's a pirate radio. So again, our common sense bill will let them easily scan through and say, oops, I'm not going to be sending money this way. So to keep this brief, I'll just turn it over to you, David, to maybe comment on how this should work in helping deprive these stations of revenue.
Congressman, and thank you for your leadership on the issue. I think one of the problems that you have in not just in New York, but in Florida and Boston and Connecticut is that your illegal operators take on the aura of a legitimate station. As a result, advertisers, including folks buying political time, have no idea that they're buying advertising on an illegal station. I think it would be important for the FCC to create transparency, which would be to list all the stations in a market that are in fact licensed by the FCC, list all the stations that it knows are illegal, and that list, making it easily accessible so you don't have to dig down 12 layers into the FCC database, but make it a website that's publicly available and easily accessible, would go a long way towards advertisers understanding, oh, okay, this person isn't licensed by the Federal Communications Commission. And I think that transparency in the marketplace would be very, very important to helping to resolve those who are facilitating illegal pirate operations, sir. I think it's a great idea.
Yeah, well, and hopefully, as you say, let's list the illegal operators. Hopefully, under Chairman Ajit Pai, he'll be putting them out of business instead of listing them.
We hope, absolutely we hope. And with the help of Congress to actually increase the enforcement tools and your suggestion, I think that will go a long way.
Well, thank you for your testimony. Madam Chair, I yield back.
Gentleman yells back. I have questions that I'm going to submit in the interest of time. And Tim and Mr. Gessner, they'll come to you. Looking at the efforts we're doing on streamlining and how those with the FCC, how that will help speed broadband deployment. But I will submit that, Mr. Madigan. I've got one that will come to you. Will you see Mr. Tonko on for either submission or questions or a real quick ask?
Real quick ask, and I thank you for waving me on to the subcommittee, Madam Chair. I have several serious concerns with pirate radio and the weakness of current enforcement, which in turn has encouraged pirate radio operators to continue undeterred. For years now, I, along with many members of New York and New Jersey delegations, have voiced our concerns on this issue, yet pirate radio operators are as prevalent as ever, and their actions have been met with few consequences. This legislation obviously comes in response to the growing number of pirate radio broadcasters in the region. that are harming consumers and public safety. According to complaints filed with the FCC, the number of pirate FM radio stations throughout New York City could outnumber the number of licensed operations, while the problem in northern Jersey may be equally as pervasive. In Albany, we had a problem with private radio operators where a pirate radio station was interfering with another legitimate station and was a nuisance to my constituents who were exposed to oftentimes what was vulgar language. I've worked on this legislation and am proud to have done so in a bipartisan way with Congressman Leonard Lance, and I hope that this committee will work and move this forward. To Mr. Donovan, Mr. David Donovan, what effect can pirate radio have on the emergency alert systems?
What it does is it interferes with those who rely on the emergency alert system, consumers who are listening to the radio. Pirate stations don't participate in the alert system, and the pirate stations actually interfere with the EAS signals that consumers rely on. In addition to that, it also interferes with any important life-saving news that follows up. You take it one step beyond and apart the EAS, the interference to FAA frequencies is rather scary because the enforcement is post hoc. The interference occurs while the plane is trying to land, and then you have to go try to find the pirate. And those situations taken together create a very dangerous situation, sir.
Thank you for that clarification, Mr.
Mr. Tonko, I need to limit you to that question. Mr. Schrader has come in and they have called the vote.
Okay,
if you
thank
don't mind.
Okay, thank you, sir.
The gentleman yells back. Mr. Schrader, you're recognized 3 minutes.
Thank you, Madam Chair, and Ranking Member Doyle for allowing me to sit in. Sorry I couldn't spend more time here throughout the hearing. We're bouncing back and forth. We've got another hearing in the Health Subcommittee that we're taking care of, too. I just want a few minutes to speak in favor of H.R. 3787, the Small Entity Regulatory Relief Opportunity Act. It's a bill I'm working on with Representative Ladd. I want to thank him and his team for all their help and support. Good bipartisan effort here. Every member of the committee wants to expand rural broadband. The answer to doing that isn't necessarily always more money. Burdensome regulations harm many of these small entities' ability to grow, expand, and hire new employees. And maybe we can do something to alleviate some of those burdens. Hopefully, by establishing some of these streamlined procedures in the bill, by obtaining waivers from regulations that are often unnecessary and not even designed for these smaller entities, we provide a little relief for our small telecom providers with a little greater certainty and efficiency to help them to continue to do the things they do best for our very, very small and rural communities. At the basic level, we're finally recognizing locally based small businesses do not have the same ability as major corporations to comply. Many of these small entities have an entire workforce of like 8 or 10 people. They don't have the resources or floor of lawyers to file petition after petition with the FCC. I think it's incumbent we all recognize and acknowledge that these that there are unique business regulatory challenges for these small entities, and we're trying to help them with this bill here, and would hope a committee and Congress and gentlemen out there would share and consider this bill. Thank you very much.
And I think there's been plenty of support expressed for that today, and also Representative Stewart has entered the room, and we thank him for the work that he has done on the suicide bill. Seeing there are no further members wishing to ask questions for the panel, I want to thank our witnesses very much for your patience today, for being here with us. As we've said, it is a busy day, just a few things going on, both in energy and commerce and on the floor. Before I conclude, I ask unanimous consent to enter the following documents in the record: Mr. Donovan's slide and Mr. Lance's New York State Broadcasters Pirate Radio Study. Without objection, so ordered. Pursuant to committee rules, I remind members that they have 10 business days to submit additional questions for the record, and I ask that each of you witnesses respond to the questions within 10 business days upon receipt of those questions. Seeing no further business to come before the subcommittee today, the committee is adjourned.
Thank you. Mark. Good job, Tim. Yeah, there we go. Yeah. But we're taking it over. We're taking over the world. That's right.
We've been talking back and forth like crazy. So. Hey, Connor and Lucy.
Thank you. Nice to meet you too.
Here's my card too. Just glad to sit down.
second.